just brimming with new information to share with you. There's a lot of stuff going on these days in a lot of different areas. And as I started thinking about what I wanted to talk about this morning, my thoughts started kind of loosely organize themselves into three areas. Things you need to know to keep your license status good, things that will be helpful to you to stay out of court, and lastly, things that you need to keep in mind so you stay out of jail, which is always a good idea. There's some overlap of all those things. Typically before you go to jail, you tend to spend some time in court, for example. But anyway, we'll plow through some of the things I have for you. If you have questions, we'll keep it informal. Feel free to interrupt me. I'm happy to answer any questions. First of all, as far as license issues, there's a few things going on that you need to know about. First off, there's a new statute, Senate Bill 676, Business and Professions Code, Section 10148. It is now illegal for you to destroy or alter or modify or spindle or mutilate, on and on and on, any parts of your transaction file. That seems like kind of a no-brainer. I'm not sure why they needed a statute to say that. I think probably that principle is covered in a lot of other areas. But it's worthwhile to keep that in mind. Generally speaking, it's a bad idea to ever engage in changing a record of something that happened. If you do end up in court or there's some challenge made or there's an investigation, having done that, things tend to unravel as you get into it, and it's always a big problem if a file has been altered. One of the things lawyers love to see if they find out some opponent in litigation has played games with the file. You can find that out and prove it. You can just twist and torture the person in front of a jury and have a great time with it. So it's a good idea just to keep that in mind. There are some new administrative regulations pending from the commissioner. And I want to take just a minute. Some of you may not be real familiar with the concept of administrative regulations. There's different kinds of laws in the state. And generally the legislature meets and decides the big issues. They decide what new statutes are going to be passed. The legislature tends to paint with a broad brush. You might have a new statute that's just a few sentences long that kind of announces what the intent is, but it doesn't get to all the bloody details. Typically, a comprehensive legislative scheme like the real estate law that governs licensing of brokers and salespersons involves provisions where the real estate commissioner, and in the case of real estate, is authorized to promulgate regulations. So the legislature puts out a big picture of what they want to have happen, and they empower the real estate commissioner to work out the details. And the commissioner does that on a fairly regular basis in a number of areas. There are a couple of areas where tentative regulations are out. We're waiting for final regulations. One of those areas is in the use of team names, which is, as all of you know, has become quite common and popular in recent years. Technically speaking, to properly comply with the real estate license law, what should happen when there's a team name working is that the broker for that company should file a formal fictitious business name statement in the county, submit it to the Bureau of Real Estate, get their approval for use of that name, and go ahead and proceed in that fashion. That's awkward for a lot of reasons. Issues come up, for example, when an agent leaves the employ of a broker and goes somewhere else. Who owns the team name if the broker's registered the fictitious business name? So the Bureau of Real Estate, see, I still can't get used to this. The Bureau of Real Estate has some regulations that are in the works that should be out. We are kind of hoping some of those formal requirements will be relaxed. Last week I heard from both an associate counsel of the Bureau as well as an associate commissioner, and it sounds like from what they were saying that probably the regulations are not going to require the formal fictitious business name filing if the situation is such that it's not likely the public's going to be misled as to who the broker is, if the name involved is descriptive and not really fictitious. For example, if it says John Smith Neighborhood Specialist, that's fine because it's got the name of the person. If it says John Smith and Associates, the Bureau would take a little bit more dim view of that because you can't tell who the associates are. It truly is a fictitious name. So anyway, keep an eye out for that. Those regulations probably will be middle of the year, maybe later part of the year before they're finally finalized. This was mentioned in the spring bulletin of the Bureau. There'll be more on it to come. The other thing that's still kind of in the regulatory stage, they haven't worked out all the details yet, is the new cite and fine procedure. Traditionally, when the Bureau of Real Estate or its predecessor went after your license, they would file something called an accusation, which is a formal document. It's kind of like an indictment. It spells out all the things they claim you did wrong and tells you what they plan to do about it. They're going to revoke your license, they're going to suspend it. There are a broad class of problems that were arising that didn't really warrant that severe treatment. So the Bureau came up with the idea of issuing what almost is like a traffic ticket. It's a cite and fine letter for something that's deemed a somewhat minor infraction that doesn't really justify revoking or suspending a license. They have the power to issue a citation with a fine up to $2,500. You can either accept it, or there's a procedure for challenging it if you think it was issued in error. Exactly how that's going to work is still kind of being dealt with. So those regulations are expected out middle of the year, probably either April 1 or July 1, I think, are the two target dates where we might see them. Another issue that's out there that's still kind of being kicked around at the Bureau level is supervision of salesperson advertising. As all of you know, brokers are charged with supervising the salespersons licensed under them. The question has come up in recent years, what level of supervision is required of the websites that individual sales agents maintain? And I understand it's gotten to be a pretty big problem. For example, I heard last week there apparently is a salesperson down in San Diego who has a separate URL for every single condominium project within the city limits. And I imagine that's probably hundreds of projects. For those of you who are brokers, how do you regulate that? How do you monitor it? What we heard from the Bureau representatives is that they don't really expect you to be clicking on each of your salesperson's websites every single day and looking at them. But you are charged, if you're a broker, with adopting a policy and procedure for keeping an eye on those websites. So you probably need to have something in your written policies and procedures, if you're a broker, about at least preliminary approval of any website that one of your salespeople set up, and then some method for tracking that, for periodically sampling what's going on those websites. So if you're ever questioned about it, you can respond and have a fighting chance of avoiding problems with the Bureau. I understand that there have actually been disciplinary actions taken against brokers solely for their failure to monitor salesperson's advertising. So just something to be aware of, keep in mind. Let's move on to some of the new civil things. There are a number of new statutes in California as usual. A few of those are worthwhile keeping in mind if you want to stay out of the court and avoid civil problems. There is a new statute that affects adjoining neighbors. When you have neighbors on either side of you and you have a fence issue, it's always pretty much been the law in the state of California that adjacent owners are jointly responsible for any fences on the property line. It hasn't been real clear how that works itself out, though, in practice. I've got good neighbors on both sides of me. Within the last couple of years, I've worked with each of them to either, in one case, repair a fence, and in one case, replace a fence. It was really easy. You get together, you decide what you want to do, you exchange checks, decide on a contractor, and go ahead. It doesn't always work that easy in the real world, though. Last year, I took a case to trial that involved a 3-foot fence between two property owners on a lakeside development. And each of those people spent tens of thousands of dollars fighting over this stupid 3-foot fence, and it finally went to trial, and we won. But that fence, it has to be the most expensive fence per foot in history. So this new law basically provides a framework for how you can go about securing neighbor approval. It spells out a detailed list of things you need to put in a notice to your neighbor about what you think the problem with a fence or wall is, what you think the fix is, what you think the proposed cost is. There's a few other items that are in your outline. And then the neighbor has a chance to respond to that by either telling you, yeah, we agree, or no, we don't think that's reasonable, or we think there's a less expensive alternative that should be considered. So that's a helpful development in the law. The problem with this statute right now is that it doesn't really spell out what happens clearly if there isn't agreement. If you give your neighbor a notice saying, gee, I think we should build a new concrete block wall and the cost is going to be $5,000, and the neighbor says no, what happens then? Presumably you can go into court, I suppose, and ask the court, ask the judge to decide the issue. But it leaves something to be desired in that area, but it's a helpful first step. On the disclosure front, as most of you I'm sure know by now, there's a new requirement that there's going to be a new addition to the transfer disclosure statement having to do with construction defect claims and lawsuits. That's something that I'm sure most of you would disclose anyway, even without that being in the transfer disclosure statement, because it's almost always material to a piece of property in a transaction that there's construction defect litigation pending or threatened. But now it's going to be right in the form, so it provides an easy place to disclose it. There's a new rule having to do with short sales. Actually, it's an extension of the rule from last year having to do with short sales and foreclosures. As I'm sure you all know, the legislature took action last year and said we're not going to have deficiency judgments in favor of lenders following a short sale or following foreclosure that results in a junior purchase money lien being wiped out. The problem with that law that's become apparent is that it didn't have anything in it, didn't have any teeth that stopped those lenders from continuing to have a barrage of a letter writing campaign and continuing to ding the credit of people that didn't pay off the obligations, even though clearly they could no longer enforce them. So this new statute, it's Senate Bill 426, it modifies Code of Civil Procedure Section 580B and adds some language. So now, not only is it not collectible, if you went to court, they're not supposed to come after you and try to collect it or do anything along. They can't take any further action, basically, inconsistent with that rule. That'll be helpful. I got a situation on my desk now where a second trustee was clearly purchased money. It was wiped out by the foreclosure of my client's first trustee. The holder of the second trustee, it's just once a week they get a letter demanding payment. They continue to report it on the credit reporting agencies. It's an ongoing problem. This new law should help us cut those things off. Smoke alarms. This is not a new law, but it's kind of an extension of the effective date. Starting July 1, 2014, fire marshal is no longer going to approve a smoke alarm that doesn't have a permanent battery, non-replaceable battery is the term, that should last for at least 10 years. And that doesn't sound like a very big deal, but if you're a landlord or a property manager and there's a fire and somebody gets killed, boy, you better have had the right smoke detectors and you better have been in compliance with that law. You probably all read the story, I think it was just this year, a few weeks ago, in the LA Times about that German architect who remodeled a custom home. And what he did is he added a couple of fireplaces that didn't have permits for them and weren't up to code, weren't the proper type of fireplace. There was a fire that broke out. One of the responding firemen was killed in the fire and he was prosecuted criminally. In fact, he was sentenced, I think, just a week or two ago to, it wasn't a long sentence, but it was a pretty clear warning to people who don't comply with safety laws having to do with construction. Senate Bill Section 752 closes a big gap we've had in California law for quite a while, having to do with how commercial and industrial common interest developments are regulated. For residential condominium and planned developments, for probably at least 20 years now, we've had the Davis-Sterling Act, which spells out in considerable detail how owners associations need to work, how the common areas need to be set up, how they need to be managed, how they need to be maintained, what kind of reserves need to be kept. We didn't have that for commercial and industrial projects. The Davis-Sterling Act had provisions that sometimes applied to certain commercial and industrial projects, but it was sort of hit and miss. And we've been involved in litigation over commercial and industrial common interest developments, and it was always difficult to figure out what parts of the Davis-Sterling Act applied, what didn't, and there's just kind of a big void. That's been filled now with a pretty comprehensive statutory scheme, similar to residential developments, but different in some ways as well because of the different nature of the property. Subdivision Map Act, if you develop property, there's been a big glut of approved applications in city and county governments for projects that just basically were dead in the water because either the economy was bad or because financing couldn't be obtained. A lot of those projects that have vested rights were expiring. There's a law that now allows counties and cities to extend those for up to a couple of additional years, so that's helpful if you do any development work or work for developers. The financial elder abuse laws in California have been strengthened. If you're not familiar with them, for several years now there have been laws on the books that make it a crime and potentially and also impose civil penalties for anybody who abuses a senior citizen. Anybody who's reached the age of 65 or meets certain other criteria for mental incompetence. And this is important to you guys because you can easily fall into the trap and get hooked into this law without knowing it. The law basically provides that anybody who takes or obtains or misappropriates the property of a senior citizen or assists somebody in doing so can have a problem. That's where you guys can inadvertently end up in the wrong place on this law, because if you're representing somebody who's doing that, technically you can be seen as assisting that person, and all of a sudden you can have a bunch of problems on your hands. The new law modifies the definition of undue influence, broadens it, and makes it easier to prove. So probably the thing you want to keep in mind and take away from that is just kind of keep a little hook in the back of your mind. If you're working with the property of a senior citizen, just maybe a little extra scrutiny is in order. Make sure your file is squeaky clean. Make sure all your communications are good. If you run into any question, stop and make sure you got everything figured out. I litigated a case a couple of years ago where a 65-year-old woman past the age of 65 had the house she had lived in for many, many years. Broker listed it under market, sold it the same day, considerably under market, to a colleague and friend of the broker without it ever being exposed to the market. And you can imagine what happened. Now there's an interesting fact that came up in that case. The woman's daughter found out about what was going on before escrow closed. Called up the broker, said, hey, stop, time out. I got a power of attorney, I manage my mom's affairs. She's not capable of making this decision. It doesn't look like a good deal on the surface of it. I need time, this needs to be looked into. They didn't stop, they stepped on the gas and closed the escrow a couple days later, and they got hammered. So watch out for situations like that. If you end up in a situation somebody brings to your attention a possible problem, stop and make sure it's looked at really carefully and vetted before you proceed to close the deal. There's a couple new cases I wanted to mention, and just real quickly, I know most of you know what a quote-unquote case is, but everybody's always talking about, gee, there's a new case about this, or a new case discusses that. Well, some of you may not realize what a case is. And one of the things, we have a body of statutory law in California which consists of all the laws that the legislature enacts, but we also have what's called common law, which is basically law that's just kind of evolved over time, and the courts tend to announce what that is. Courts also interpret what the legislature does, because as I mentioned earlier, frequently laws are enacted that don't have all the details worked out, and there are gaps that need to be filled in. And so we have what are called reported cases. What those are is published opinions of one of the courts of appeal or the Supreme Court in California. And for a case to get to be a case, not just every case that ends up in trial becomes a quote-unquote case. Of the many thousands of trials that occur in the courts throughout the state every year, a small percentage of those are taken up on appeal and reviewed by a higher court. And of that small percentage, an even smaller percentage are deemed worthy of publication because they involve some novel issue, or there's something that needs to be, there's some gap in the law that needs to be filled in. But once a dispute between two people gets through all that vetting process, and the Court of Appeal decides that its opinion should be published, it's then bound into a book, it's made available online, and at that point, that case can be used as precedent. I can take that and say, well, gee, last year there was a common fact pattern involving the same issue. I can say to the court I'm in front of, you should follow this because it's already been something that's decided. So anyway, there's a couple cases that, in addition to being humorous, so they have some value, also should maybe make you just pause just a moment before you do certain things. It's a case called Bentley Reserve LP versus Papaliolios. Came out a few weeks ago. It involved an anonymous post on Yelp where a tenant of an apartment project accused the landlord of being a sociopathic narcissist, I believe the words were, who had killed 3 tenants. And the landlord found out who it was or suspected who it was. There was litigation. At trial, the defense was, well, gee, this is a country where we have the First Amendment, that's protected free speech. And the Court of Appeal said, no, there are limits to free speech. And accusing somebody of criminal conduct and killing people and all those things goes beyond what you're allowed to do in terms of your First Amendment free speech protections. So I understand that there is a lot of traffic on social websites these days involving brokerage practices and listings and things like that. Just put a filter in the back of your mind before you post something. Just have it occur to you just for at least a fleeting second, gee, am I going to cause any problems for myself if I post this? I had a client, I concluded some litigation for a client involving a construction defect last year, and she hated the contractor, just couldn't stand him. When she recently found out he was running for office somewhere. So she called me up and says, hey, am I free to just slam this guy? Can I go online? And I said, well, hang on a minute, let me go back and look at our settlement agreement, because it was a case we resolved. I said, you know, we don't have a confidentiality provision in your settlement agreement, but I'd be real careful what you publish about the guy. Defamation law, libel is saying something, writing something bad about somebody, slander is saying something bad about them. One of the main defenses you have is that, gee, what I said was true. So if somebody really is a crook, and you're saying he's a crook, well, yeah, I guess technically you would be protected. But the problem is you still may have to prove that's the case, and you may still be subjected to long and expensive litigation. So it's better to avoid that kind of controversy at the outset if you can. Second case I wanted to mention to you was a case where you guys all see the preliminary title reports you get when an escrow's open. I think more often than not, I don't know what percentage, but probably 80 or 90% of the prelims I see have at least one exception for an easement of some nature. Typically they're utility easements where Edison or a water company or somebody has the right to maintain pipelines. Sometimes they're access easements, sometimes they're oddball things. This case involved an access easement. And on the surface, it didn't look like any big deal. It looked like the adjoining property had the right to traverse across the property at a certain point. But what happened, the parties got into a dispute. The landowner that had the access right decided they needed to improve the other property to be able to properly utilize this access right. And to properly improve it, it required a retaining wall. And the court looking at this said, yeah, in this situation, that little access easement actually carried with it the right of the easement holder to go onto the other property, construct a retaining wall. So the moral of that story is, I think in your practices, when you run across those things in a preliminary title report, if you're asked by your client, what does this mean? Don't just blow it off. You say something like, ah, it's nothing, don't worry about it, or that's common, or it's routine. If something like this happened, they'd come back and say, hey, you told me this was routine. Now this guy has the right to come on my property and build a retaining wall, which interferes with my use of it. If you're asked a question like that, you'd probably be well served to refer the person to maybe a surveyor to actually scope out the exact dimensions, or to get legal counsel, something like that. Whenever I have usually the transactions I handle in my office tend to be bigger commercial and industrial things, and I always get prelims. I ask for full backup and look at this stuff, and frequently I end up telling people, you really got to talk to an engineer about this, or you got to go talk to a surveyor and see exactly what you're dealing with, if there's any question. Now for the one thing I wanted to mention too, in fact, Tom was in a meeting with me last week at the San Diego Car Convention, and another lawyer there had a really good idea. And doing what lawyers do, I immediately stole it and started using it myself. But a common fact pattern that you run across, I've seen it quite a bit, is that a seller wants their property to look nice to put it on the market, so they do all kinds of cosmetic things to fix it up. If later on the buyer discovers there was a defect, one of the big claims is that the seller knew about it, and I know they knew about it because they intentionally tried to cover it up. I had a case a couple of years ago where there was some water damage. The seller had replaced some siding, had done some painting. The claim was, well, gee, this is proof of intent. Now we're talking about fraud. We know the seller intended to lie to us about this because they went to all these lengths to cover it up. But what this lawyer suggested is that maybe in those situations where there's been cosmetic repair to prep a property for sale, you might want to consider disclosing that in writing. maybe even attach a list of what the seller did in the way of fix-up work to the TDS. Can't hurt, and that would tend to diffuse any claim that there was an intentional cover-up. If there was an intentional cover-up, why would you disclose what was being done? So not a bad idea. Some of you may already do that, I don't know, but I think it's not a pretty good idea to do. Now for the fun stuff, the criminal things. How are we all going to stand at jail this year? The first new statute I wanted to mention to you probably doesn't have much to do with real estate, but I couldn't resist including it because I am a parking scofflaw. And the new law, you remember last year there was a law that says counties and cities are allowed to enact ordinances where anybody who parks in front of a broken parking meter can be cited. So it wasn't a free pass if you could find a broken parking meter. Now the legislature has reversed that. I'm not sure what the rationale was, but they said now no longer. Now if you can go out, if you're resourceful enough to find a broken parking meter, you're absolutely free to park there. So the search is on. But you gotta hurry. That law expires on January 1, 1917. I don't know what the rationale for that is either, but that's part of the law. There's a couple new things on the tax front you need to keep in mind. If any of you are involved with transactions that are 1031 exchanges where the replacement property is out of state, Franchise Tax Board has a new reporting requirement. You have to disclose on your state income tax return that you've exchanged into property that's beyond the grasp of the California Franchise Tax Board. And the awkward part of this law is that every single return, every year thereafter, you have to continue to file a schedule that says that, yeah, I exchanged into this property. For as long as the gain remains unrecognized, you have to every year file this return. I tried to get a copy of it just so I could see what it looked like, and the Franchise Tax Board's website basically has a coming soon announcement on there, so I don't know what it looks like. I think it's probably just a schedule you include with your Form 540 when you file it, but anyway, if you have property you exchange out of state, or if you have clients, something to keep in mind. Also, there's a new law that allows it's been the law for a while that the Franchise Tax Board shares information with local governments about for business license purposes, which I know all you love business license fees and taxes. That was extended, so the Franchise Tax Board is going to continue doing that all the way out until 2019. There are actually several new ways you can get yourself into trouble having to do with immigration status of your colleagues or your clients. Senate Bill 666 provides that professional licenses can be revoked in any situation where the licensee has threatened to turn somebody into immigration. If you're threatening any current, former, or prospective employee or family member, I would think that would probably also apply to people you do business with, such as clients.
Tenants?
Don't go there, tenants. Yeah, I mean, it's a new protected class essentially. You got to be real careful with that. And then that kind of brings up the next subject, which is even a bigger potential problem, is the whole subject of extortion. Over the years, I've heard, I don't know how many times I've heard somebody threaten somebody else, but I'm going to turn you into the immigration's one possibility. More commonly, I get people all the time wanting to gain an advantage in my civil lawsuits by ratting somebody out of the IRS. You can't do that. In California, there's a crime called extortion, and basically that crime consists of any influence you exert over somebody to gain an advantage in a negotiation or a civil matter where you convince that person to give up their property or a position that they have under threat of some kind of fear. They voluntarily do what you want them to do, but it's under threat of some kind of duress, that something bad's going to happen to them at your hands if they don't. And you have to be really careful how you threaten people in your businesses and in my business too. If somebody refuses to close an escrow, it's perfectly legal for you to threaten them with a civil lawsuit. You can say, my client's going to go hire their lawyer, they're going to sue you, and it's going to cost you a fortune and ruin you. That's not extortion. But if you say, if you don't close this escrow, I know what you've been doing, I'm going to the IRS, that is extortion. Anytime you're threatening somebody with a criminal consequence to gain an advantage in a civil matter, you've got a problem. So watch out for that, and especially in this case, it applies directly AB 524, which amends Penal Code Section 519, has to do with threats of reports of immigration status. Can't use those to gain an advantage. Then there's a couple of things that aren't new statutes, aren't new cases, but they've hit the news, hit the papers just this month that are really interesting, and you need to watch out for them. First one has to do with adverse possession. You guys probably, some of you may be more familiar with that than others. I think on the license exam, there might be one question sometimes having to do with adverse possession. Sometimes it may not be covered at all. Adverse possession is an arcane concept that goes back to Old English law. It basically exists on our books as a way of settling stale title claims. And what it says, for those of you who don't remember, is that anybody who goes out and openly and notoriously occupies a piece of property for 5 years continuously and pays the property tax on that property can gain title to it. It's not quite that simple. You need to do all that, pay the taxes, and generally before your title becomes marketable, where you can actually sell it to somebody and get title insurance, you have to go through a further step of filing a title action in court and getting the court to give you a judgment that says you're now the owner by virtue of adverse possession. And that sleepy little law, I've been doing what I do for about 30 years, and that sleepy little law probably came up in my practice maybe 3 or 4 times over the first 25 years I was in practice, usually more often in terms of the easement equivalent, which is called a prescriptive easement, where it's very similar, but all you do is you gain easement rights. Well, in the last 2 or 3 years, I've litigated 3 cases involving adverse possession, and we've still got more coming in. What's happened is that people have looked at this law. It's become a new cottage industry. It's become a full-time business for some people, adversely possessing property. One of the people I went to trial against last year, we defeated his claim, claims to have adversely possessed over 1,000 properties. It's a full-time business. 3 years ago, the legislature stepped in, recognized the abuse that was starting to occur, and said, we're going to make it tougher. It used to be that you had to pay the 5 years property taxes for the 5 years you were occupying the property, but you could wait until the end of the 5 years, go in just on the eve of a property tax sale, bring all 5 years current, you've complied. They said, no, we're not going to allow that. Now you have to pay the taxes, keep them current as they occur. What that does, it's a little bit of a disincentive. It means the person trying to adversely possess property has to make that financial commitment twice a year for the full 5 years. But anyway, what's going on is there are people out there now that are just going crazy grabbing properties. And even though it's legal to do that, what typically happens is the means they employ tend not to be terribly legal. They tend to lie, cheat, and steal in the process of doing it. They will falsely testify, they will create phony documents. The case I had, among other things, involved a phony deed that was created and recorded, which is itself a crime, to record a false document. But what happened earlier this year up in Fresno, our Attorney General, Kamala Harris, announced that they had cracked open a ring. They had arrested 5 people, 2 of whom were lawyers, for engaging in these criminal antics in connection with trying to adversely possess property. So if you ever are interested in adversely possessing property, or if you have any clients who are doing that, keep in mind that whole practice has now really come under scrutiny. It's still perfectly legal to adversely possess a piece of property, but you need to be careful how you do it. Make sure you're not stepping over the line in some area as part of what you're doing. 1 minute. I'm told I have 1 minute, right? One minute. Just real quickly, too, Trustee Sales. There are, it used to be a joke, way back when, Trustee Sales were rigged, the auctions were rigged. People who go to the sale, they would agree in advance that they're going to suppress the prices. They're going to say, well, there's 5 of us, you take this first property, I'll take the next one, you take the next one. That way we get the properties for a whole lot under market value, less than what they would normally bring at the sale. Well, up in the Bay Area, the Department of Justice and the FBI have been going after people for the last several months, and as of last week, there have been 40 guilty pleas entered in that. People doing that exact thing. They'll get together and they'll rig a bid to suppress it. So if you get involved in trustee sales or have any clients that do, make sure you don't even start to hint at anything that might tend to be an agreement to control the price of a sale. So, anyway, that's it. Any questions?